Folks, there are a number of rulings that came down today from the Supreme Court. One of them is just unbelievably dreadful. Folks, the case is Jones versus Hendricks. And this is what the Supreme Court has ruled in a 6-3 decision. And it impacts future cases involving prisoners who seek to challenge their convictions based on an intervening change in interpreting a criminal statute. In the ruling, the Supreme Court denied Marcus D'Angelo Jones' petition for a writ of habeas corpus that dealt with his conviction and the sentencing. And the case concerned two statutes, which provides post-conviction remedies for federal prisoners. He was convicted in 2000 on 2 counts of unlawful firearm possession by a felon and one count of making false statements to acquire a firearm. Now, what's crazy here is that he contends that the federal courts got the sentencing wrong, got the conviction wrong. So he felt that he should be resentenced. The courts, they understand that the federal courts made a mistake. They actually made a mistake. But they went, sorry, dude, can't help you. Judge Ketanji Brown Jackson, folks, issued a blistering 50-page decision. I'm going to read some of that from you in just a second. I want to bring in my panel right now to talk about this because, again, when you look at the previous story and this one, they all go together. Greg Carr, Department of Afro-American Studies, Howard University out of D.C., Reese Colbert, host of the Reese Colbert Show on Sirius XM Radio out of D.C., Candace Kelly, legal analyst out of South Orange, New Jersey. Candace, I'll start with you. How unbelievable and ridiculous is this Supreme Court decision?
It's very ridiculous because of the fact that it sets a precedent where somebody essentially just can't challenge a conviction that is wrong. In this situation, you had a gentleman that he did not know that he had even committed a felony on record. And when he went to go buy a gun, again, he didn't know. So when he bought the gun, he didn't even know that it was a felony for him to buy a gun. And so the law states that anyone who knowingly has a felony cannot go and do something like buy a gun, for example, because that creates another felony. And that's where the sentencing came in. He challenged this. And the Supreme Court said essentially that, well, even though the law says that you didn't know about the felony and that was okay, you're actually going to still stay in jail. The sentence is going to remain the same. And as Ketanji Brown Jackson wrote in her 50-page opinion, as you said, she said essentially this sets up so that anybody who believes that they have been wrongfully convicted, they just don't stand a chance on having the opportunity to go back to the courts and saying, I didn't know, or this wasn't even a law that was on the book. And so those are some of the issues that are coming up in this particular Supreme Court case. The overall effect is that people who are behind bars that are innocent, they get to stay behind bars because of the Supreme Court's decision.
I'm reading a piece here, Greg, from Slate.com by Leah Littman. In fact, her work was quoted by Judge Ketanji Brown Jackson in this. And what she wrote is, again, when you think about this case, you just sort of shake your head and go, what in the hell are these people thinking? What are they thinking? As Candace said, Judge Ketanji Brown Jackson, in her dissent, she said the opinion unjustifiably closes off all avenues for certain defendants to secure meaningful consideration of their innocence claims. What was crazy about this is that, and this is what she said, essentially the case involves this scenario. What if it turns out that the federal courts that heard your criminal case made a mistake? And as a result of the court's mistake, you were convicted of something that isn't actually a crime at all. because federal law doesn't prohibit what you did. Or, as a result of the court's mistake, you were sentenced to more time in prison than the law says you could be sentenced to. Can a federal court later correct the error in a federal habeas corpus proceeding when you challenge your conviction or sentence? Clarence Thomas, Alito, Gorsuch, Kavanaugh, Roberts, Barrett, they go, sorry. You're behind, going to stay in prison. This is when we talk about how elections matter, because who became president is actually who appointed Kavanaugh, Gorsuch, and Barrett, Greg.
Yeah, absolutely. And also Clarence Thomas. I mean, in the sense that these members of the Supreme Court, most of them were appointed by presidents that lost the popular vote. Of course, once again, indicting the silly Electoral College. But it is consistent. That's one thing you have to say. I mean, we talked to Corey Robin, the author of The Enigma of Clarence Thomas, at the Black Table. And one thing, and I recommend if folks want to understand the mind of Clarence Thomas, that they read Corey Robin's book, Professor Robin. Clarence Thomas is very clear when it comes to these kind of issues. And as you named, those justices are right with him. They prefer finality when it comes to sentencing over accuracy. Justice Brown Jackson, in fact, opens her dissent, and you see what Ketanji Brown Jackson is doing. By the way, she's doing this with the 14th Amendment and the other cases, and I think we all anticipate she's going to do that with the affirmative action case when it comes down, the SFFA cases. She is referring back to not only the statutes, and in this case, it's the Anti-Terrorism and Effective Death Penalty Act. She's going not only to the language of the statutes, but she's going to the legislative record to see what Congress intended. And what she is saying here, consistent with the way statutory interpretation, at least as it's taught in every law school I'm aware of in the United States, is that when you look at the record, this is ironically probably could be considered an originalist interpretation of the statutes. It's very clear what Congress intended. She says that what Clarence Thomas and them are doing is reading negative intent into the statute, making it up, and basically saying that you've closed off any prisoner's right to habeas corpus to file an additional appeal. Now, the irony is, and I'll end with this, is that while they're making it up because they believe in two things: one, finality over accuracy. The courts did it. I don't care if it's wrong. It's the courts. And by the way, that also apparently applies to them flying around on private jets and doing everything else. They believe they're above the law. That's number two. But also, like you said, the connection with Crosley Green's case is also clear. When the Florida court could not get around the fact that, in fact, they had not had the Florida prisons hadn't had custody of Green. That custody was interrupted or told by a couple of years when the lower court ruled for him. Technically, that means that the parole board, the PPRD, was supposed to factor that in his parole. Instead of recognizing their own regulation, the Florida regulation that would require them to do that, they simply ruled that they would take no action on that. In other words, if we can't get around the rule, we'll just pretend like it doesn't apply. So that's another avenue of appeal for Green, but you see what's at play here. This is pure politics, as you say, Roland.
The journalist writes this in her piece in Slate, Reese. It says, it's also important to note that the pattern here. Last term, in one of the more ghastly Supreme Court decisions, the same 6-3 majority from Jones ruled for Arizona in a case where the state had loudly and proudly argued that, quote, innocence is not enough to remedy a conviction for innocent persons convicted in state courts. In that case, incarcerated individuals sought to introduce evidence that they didn't commit the crime they were convicted of or were not even eligible for the death sentence they received. One of the individuals, Barry Jones, had successfully persuaded 2 federal courts and 4 judges that he probably didn't commit the crime for which he had been sentenced to death. The court said, Too bad. It's illegal for a federal court to consider evidence of his innocence, even if that evidence wasn't ever introduced because the state appointed him an ineffective lawyer. After the 2022 midterm election resulted in a Democratic Attorney General, Barry Jones successfully, let me repeat that, Reese. After the 2022 midterm election resulted in a Democratic Attorney General, Barry Jones successfully negotiated a plea agreement resulting in his release, though this Supreme Court would have allowed the state to execute him.
I mean, I obviously don't have the legal expertise that Dr. Carr and Ms. Kelly do. I will say that politically, it's obvious that the Supreme Court and the court system is largely illegitimate. It is not about justice. Innocence is beside the point, particularly when the people that are most falsely convicted tend to be Black people, tend to be poor people. So the fact that, you know, there might be some white people who are denied their constitutional rights or denied their ability to prove their innocence, they're willing to sacrifice those people because they feel like, well, you probably did something anyway. And unfortunately, it's going to be Black and brown people that continue to be targeted, that continue to be harassed and falsely accused, that are going to have to bear the brunt of this. So as you just pointed out, and as the writer just pointed out in that article, it's going to come down to who's governor and can evaluate clemency agreements, who is the attorney general, who are your district attorneys. Those are the people that can go back and renegotiate some of these things, who can decide not to, when a circuit court or a district court overturns your conviction, not to go back and retry you or not to appeal it to the higher court to get them to reinstate the conviction. So there are multiple levels of ways where people can influence these injustices happening. But unfortunately, people are too complacent and too checked out and too uneducated and unwilling to be educated about civics and those different levers. And so we have now seen a situation where undeniably the courts that are supposed to be the arbiters of justice, which never really have been, are no longer part of the equation as long as we have an illegitimate conservative Supreme Court and all of these Trump judges still on the bench.
Candace, I can't remember the particular case, but a previous case came up where Scalia, Thomas, and others, where they basically said that, even if you're innocent, if you've exhausted all of your appeals and everything, and everything was done correctly, meaning the law was followed, and you got a chance to do your appeal. Even if there is undeniable evidence you did not commit the crime, sorry, all the I's were dotted, T's were crossed, so therefore, there's nothing for you. It is as if what these conservative Supreme Court justices are saying, damn morals, damn values, damn principles, and forget what's right and wrong. If we follow all the rules, sorry, you got to stay in prison or you die.
Roland, these are the basic principles that mothers and fathers teach their young Black children, men and women, young females and males, the basics of the Constitution. You are innocent until proven guilty. You deserve due process. You deserve to be heard in the whole process. You, according to the Brady rule, and this is what people should look up, Brady versus Maryland, decided by the Supreme Court, you have to introduce exculpatory evidence to the other side. Evidence is very important in all of this. That's how you win or lose your case. That's all we know about the justice system. It's not what you thought. It's not paperwork that was maybe lost. It's what you can prove in court. So how in the world can this man, Marcus Jones, have all the information that he needs on a federal level, proven himself throughout the court system, and still be found guilty? has nothing to do with what the Constitution was created to do. It doesn't live up to the basic principles that every layperson these days knows about. It makes absolutely no sense. I do not see how the Supreme Court is getting away with this. It locks people out of their opportunity to bring forth DNA evidence and say, it wasn't me. It locks people out of the opportunity to say this piece of evidence, just as Marcus said, was proved in the federal court on the lower levels, that this was not me. I don't know where this is going, but this is not what the Constitution was created for. Now we're at the Supreme Court. Now what does he do? This is the end. This is the worst precedent. Today was just a day of bad precedent for the Supreme Court. But this is one of the worst, because this sets a precedent for everybody who was in jail, especially African Americans, especially African American males, when we look at the numbers, who are saying, I didn't do it. I didn't do it. Even another decision, I think that we're going to get into that case in terms of, someone who was, we talked about it earlier, actually, someone who got out of jail, proved his innocence, went back in. So this is something that, we need to pay attention to. And as you said, it starts with our vote. It starts with the people who have to make sense of the law to make the right decision for those people to get their due process and know that innocent means innocent, and innocent means you get out of jail, Roland. You get out of jail. I don't understand it.